testimony broadly. The reason why is we want to be fair to everyone here and generally provide the same amount of testimony for everyone, no matter who you are, no matter where you're from. In order to ensure a balance of public testimony across the 3 public hearings and to reasonably structure the committee's business, the public testimony for today's hearing will also be limited to 5 hours in length. The time right now does not count against that. We're only going to start that running while people are testifying and answering questions. This time, and I want to stress this time is not the only opportunity that you have to provide information for the committee to consider. This is just one of many ways. First, if you have more to say than the time allows, or we unfortunately do not reach you here today, as the hearing notice mentioned, we welcome you to bring up a written copy of your testimony. Please turn that in to Dylan at the end if we get to that point. If you had more to say, you couldn't get to, or we run out of time, please turn in your written testimony to Dylan. He's going to scan that in so every member of this committee will be able to hear from you. Second, if you have any handouts with you today, as the notice mentions, please bring the handouts up front to Dylan before your testimony, and they will be provided to members of the committee. We ask you to bring 22 copies. That's for our members here. For those on the dais that are not on the committee, we might not have a copy for you. Apologize for that. I didn't know the numbers, but for the members of the committee, we will. Third, anyone is welcome to submit an electronic comment without testifying online. The electronic portal is linked in today's hearing notice, and it can be found at comments.house.texas.gov. Information can be uploaded to the portal for today's hearing through the end of today's hearing. You can also upload information to the portal for future hearings through the conclusion of those future hearings. The Texas Legislative Council also hosts a website for redistricting at redistricting.capital.texas.gov. On that website, you can find information about submitting proposed maps for consideration. Click 2020s at the top, then click Public Participation. There will be links on that page that will guide you. Finally, every member of the public is always welcome to email, contact, or call any member of the legislature at any time, and many of you have done that. We welcome you to continue to do so. So finally, logistics. For our virtual witnesses, again, we're going to take you one at a time. I'm going to announce the 4 that we will take just so that you know that your testimony is coming up. So if you're in those first 4 witnesses that I mentioned, just be ready. But we will take virtual witnesses one at a time. For our in-person witnesses, I'm going to bring you up in panels of 4. We have 4 seats right up here. If you're in here, great. If you're in the overflow room, just be listening. What I plan to do is I'll call up our 4 virtual witnesses, and I'll go ahead and tell you who the 4 on the next panel of in-person will be. If your name is called for the in-person panel, just make your way into the room up here to the front, and you can be seated at those chairs. That way, we can get to you expeditiously. Members, please hold questions for our in-person testimony until all 4 panelists have testified, and then, of course, you can question the panel. Finally, since we have no bill before us today, and we've gotten some questions about this, so I want to make sure this is clear. Since we have no bill before us at any of these first 3 public hearings, all testimony will be neutral or on, which I will verify with each of you when you come up here to testify. With that, let's get started. Our first 4 witnesses for virtual testimony today are going to be Vice Chair, for what purpose? And then click your... Just so the members are aware, since we're in the Appropriations Committee room, the technology is a little different. In order to be recognized by the chair, please press the button on your microphone. It'll pop up on here, and then we'll recognize you. So, Vice Chair Rosenthal, for what purpose?
May I make an opening statement?
The gentleman is recognized for such purpose.
Thank you. Thank you, Mr. Chairman, and thank you all for being here today. For the people that don't know me, my name's John Rosenthal. I'll be your co-host for the afternoon and evening. I'm a career mechanical engineer. I believe in practical solutions. This, in my view, is far from anything resembling a practical solution. I also note that it's an incredible responsibility for me to be here serving as your vice chair today. Sometimes oil field engineers get to take on some really big things, and I have had the privilege and the opportunity to work on some major undertakings. Nothing in my life compares to serving as the vice chair in this committee today. So I feel the weight and the gravity of this proceeding because there's a real fight on our hands. Let's face it. I'm ready for it. I know my colleagues are as well. I'd like to ask the clerk to pass out this little packet. I've got the letter from the Department of Justice, the proclamation for the governor, and the committee hearing notice. If we could please make sure that every member of the committee has this. I want to ensure that we all understand what's happening here and what's brought us here today. So members, I want you to pay special attention to the letter from the Department of Justice, which is what set this entire chain of events in motion. The congressional districts specifically mentioned by the Department of Justice are Congressional District 9, 18, 29, and 33. It's curious to me that none of these districts are mentioned among the dozen or so districts listed in our hearing notice. And I'll let you think about why that might be the case. Mid-decade redistricting is unusual. It's unnecessary. We are actually constitutionally required to redraw districts every 10 years following the census. Texas did its constitutional duty and redrew the districts following the 2020 census in 2021, and I was here for that proceeding. So that process is supposed to be about making things fair. As the population of the state grows and changes and moves around, we adjust district boundaries to make sure folks have fair representation. This process, in my view, has nothing to do with making things fair. If you look at the 4 districts in question that the Department of Justice listed on their letter, this process is aimed at removing black congressional representatives. 3 of those 4 seats are black-held seats. That is a attempt to racially gerrymander our state under the guise of unracially gerrymandering. And then 1 Latino seat. The effort to change these districts at this time has nothing to do with representing people better. It's the opposite of that. It's a power grab at the expense of black and brown communities. So here's what's really at stake. Texas is growing. The vast majority of that growth is by people of color. So I live in a world of facts. Engineers make stuff happen in real life. We use a lot of math, so hope you'll bear with me. This population growth measured from 2010 to 2020 was black and brown people. So the population during that period, according to the Census Bureau of the United States of America, grew by 3,999,994 people. That's 6 short of 4 million. Let's just call it 4 million. Of that growth, 187,252 were white, 557,887 were black, 1.98 million were Latino. So I have done the math for you already. 4.6% of that 10-year growth was white. But the 4 million drove the need for this state to draw 2 new congressional districts, Congressional 37 and 38. And by some miracle of chance, this legislature drew both of those districts to be majority white. I live in one of them. Black and brown communities already don't have fair representation. So if our population is 60% communities of color, why is our congressional delegation 34% from communities of color? So if we have a proceeding aimed at taking away their seats, we're taking away their voices, plain and simple. So, and I know I'm talking about black and brown communities, and I don't know if you are aware of this, but I'm actually a white guy. And I do feel it's especially important for me, for people that look like me, to speak out about this kind of injustice. It was Desmond Tutu that said, if you are neutral in situations of injustice, you have chosen the side of the oppressor. We need to speak up and speak out. It's on us, especially those who benefit from these systems, to have our voice in these spaces. I'm just going to end with this. Mid-decade redistricting is pointless, unjust, and we won't let that happen quietly. I'm here to fight. We all need to raise our voices to protect democracy for every Texan. Thanks for your attention.
Mr. Turner, for what purpose?
Thank you, Mr. Chairman. Before we move on to testimony, just a couple of questions, if I may. In terms of, can you hear me now?
Yes, I can. Please
Okay.
restate your inquiry.
Thank you, Mr. Chairman. Before we move on to testimony, I just wonder if you would allow me a couple of questions so I can better understand the process here today.
Chair recognizes Mr. Turner for some questions.
Thank you, Mr. Chairman. So you have seen the letter from the Department of Justice objecting to the racial compositions of districts 9, 18, 29, and 33?
I have, and I have received a copy of it here, I believe, with all of you.
Yes. And I think you said this in your opening, but just to clarify, it is that letter that Governor Abbott cited in his proclamation for the special session?
He doesn't cite to a specific letter in his proclamation. He does reference concerns, I believe, raised by the U.S. Department of Justice.
Okay. Are you aware of any other way that DOJ has raised concerns beyond that letter?
That would have to be a question for the governor. I'm not aware of any other letter, though, personally myself.
Okay. I'm not either. I think it refers back to the letter. So the letter that you've read and I've read as well basically is asking Texas to dismantle those 4 districts because of their racial makeup. And my question is, do you believe, as the chair, does the committee believe that it is legal for us to intentionally dismantle majority-minority districts because of their racial composition?
I don't believe that the letter is a specific request for us to dismantle any district. However, it's the chair's intention at all times that we are going to follow the Voting Rights Act, and we're going to follow the law. And we have no plans to this moment to change any particular district. The purpose of today's hearing is, of course, to hear from the public before we go into that process.
Well, Mr. Chairman, the letter specifically says that these are coalition districts, meaning that they're majority-minority districts, and they say that they're unconstitutional. And we urge the state of Texas to rectify these race-based considerations from these specific districts. So it seems to me they're asking us to change the districts based on their racial makeup by virtue of the fact that they're majority-minority districts.
You'd have to refer specifically what the Department of Justice wants to do or not wants to do to them. The chair obviously did not have this letter addressed to him. And as far as I'm concerned, the whole point of this process is solely to respond to the governor's call. And we're going to take up congressional redistricting in that 2-phase process I mentioned earlier. And I'd love to get to this first phase of hearing from the public.
No, I appreciate that. And I appreciate your point about the Department of Justice didn't address the letter to you or any member of the legislature. Will we be hearing from the Department of Justice today? I
am not certain. Chair's not advised whether they have registered to testify. I believe that an open invitation was sent to everyone to register if they'd like to, and the vice chair has reached out to me and wanted to invite some individuals, and I've worked with him to do so, and we'll take any of his invited witnesses out of the regular order as a courtesy to the vice chair.
Appreciate that. Would we be able to formally invite the Department of Justice to come and testify before this committee? If not today, then in
I'd be happy
Houston
to
or
talk with you
Arlington?
about that. I know the vice chair was thinking perhaps, but we can talk about that.
I think it'd be important to try to understand their legal basis for this exercise. Who are and just a couple more questions, Mr. Chairman. I appreciate we want to get to witnesses. Who are the legal advisors to our committee for this process?
My understanding is the House has retained Butler Snow, and I believe that I'm not exactly certain of whether or not they represent the individual members of the committee, but I believe to respond to your inquiry it would be Butler Snow.
Okay, but you're not sure if they're available to the entire committee?
That is a legal question. I don't want to give you an incorrect answer, right? So I'd be happy to look at that and get you an answer to that.
Okay, I appreciate that. Are there any other outside law firms that you're aware of that are involved in the process?
Not to my knowledge.
Okay. And have you had, as you've kind of undertaken this process, have you had any discussions about this process with our Attorney General's office, General Paxton's office?
I received I cannot waive the attorney-client privilege during the regular session as to the litigation. did receive a briefing of the litigation, but no, I have not communicated with the Office of Attorney General regarding this redistricting process.
Okay, and I take it from your previous comment, you've not communicated with the Department of Justice?
I have not.
Okay. How about the White House?
I have not.
Okay. How about a gentleman named Adam Kincaid?
I honestly have no idea who that is.
Okay. My understanding is he's the person who drew the maps in the last decade. Anyone with the National Republican Redistricting Trust?
No.
Okay. And lastly, have you seen any proposed maps that the White House has sent?
No.
Or President Trump's operatives have sent?
No. I believe the only map that I have seen is the one that was posted to the public portal, which I reminded everyone, anyone in the public is invited to submit a map. Just because a map is put onto that portal does not mean in any way that that is a map this committee was intending to take up or otherwise. The public is free to submit whatever the public wants.
Okay. So you've seen, no one has sent you any maps for this committee to consider?
No.
Okay. Thank you, Mr. Chairman.
Thank you, Ms. Turner. Mr. Wu, for what purpose?
I have some questions.
Yes. Chair recognizes Mr. Wu for questions.
Thank you. Mr. Chairman, I just want to follow up on Representative Turner's questions just a little bit. I'm personally very confused about why exactly we're here doing this. And from what I heard you say earlier, you've not been given any explanation or any notice from the governor of why he made the call.
I have received the same proclamation that you have received.
Okay. And this is not a process that you have personally asked for? This is redistricting, you've not personally asked for that?
Does anyone really ask to be chair of redistricting?
Well, yeah.
But I am here. No, I have not asked.
I just want to be clear that as a chair of this committee, as a chair of the redistricting committee, that you did not say, Governor Abbott, please.
No, I did not.
And as far as you know, nobody on this committee has made those requests either.
Not to my knowledge.
Do you know if any member of the legislature went to the governor and said, we really could use this right now?
Not to my knowledge.
Okay.
Again, I'm limited to what I personally know.
No, I'm absolutely. And I only know what I know. You only know what you know. And between the two of us, I don't think we know anything of why we're here.
I think the chair would say that the governor has put an item on the call. It is prudent and proper for the legislative committees to take up the items that the governor has designated. And what the legislature does with that is up to the legislature. But it's the chair's position that the governor has placed this item on the call, and we're going to take it up in a two-phase process.
And I know you keep up with this stuff. You're aware that we were recently, the state was recently involved in a trial, 3-week trial in El Paso over the maps that we passed in 21.
I have very general knowledge, not specific. I was not involved in that.
Same here. But are you aware that members of our body testified under oath in that trial saying that there was absolutely no racial gerrymandering in the current maps that we're discussing?
I'm generally aware of that.
Okay. Thank you. And you've not seen anything that would speak to the contrary?
No, I've certainly never seen any indication that any map that has been passed out of this legislature, anytime I've been in the legislature that I voted on, would violate in any way the Voting Rights Act. But again, I'm not a legal expert. I'm going to just tell you what I know, and of course I voted on that. I had an opportunity to vote on the same maps that you did.
Have you personally seen any demographic evidence or any data of any kind that would suggest that or would say that there needs to be a mid-cycle redistricting?
Well, I think whether or not there needs to be mid-cycle redistricting is a matter of opinion. To your first question about whether I've seen evidence, I believe, and correct me if I'm wrong, I think your question was alluding, have I seen evidence of the current map engaged in some type of inappropriate violation of the VRA? Mm-hmm. And I have not.
Okay. All right. Thank you very much.
Thank you, Mr. Wu.
Mr. Chairman.
Dean Thompson, for what purpose?
I happen to see the letter that the DOJ sent down here, but I want to say that the Attorney General of Texas answered them, and they said that the Texas legislature did not pass race-based electoral districts for any of those 3 political maps. The Texas State Senator Joan Huffman who chaired the Senate Redistricting Committee, testified under oath that she drew Texas districts blind to race and sought to maximize Republican political advantage, balanced against traditional redistricting criteria. And he went on to say in his letter to the DOJ that the Texas legislature has led the nation in rejecting race-based decision-making in its redistricting process, and it has drawn its current maps in conformance with traditional, non-racial redistricting criteria to ensure Texas continued to adopt policies that would truly make Texas great again. And Mr. Chairman, I resent the the United States Department of Justice sitting down here accusing our state that we have drawn some race-based maps and actually putting scorn upon our elected officials, because you and I know that Dan Patrick never would have passed a map out of the Senate, and we never would have passed one out of the House that would have included this. And again, not trying to be dilatory in your getting to the witnesses, I just resent this, and I just think that this is a waste of good taxpayers' dollars that we ought to be putting somewhere like in the flood victims. And we flood in Harris County, incidentally. We need some of this flood money, too. Thank you.
Understood, Dean Thompson. Okay. Can you push a button? Well, Ms. Gervin Hawkins, for what purpose? Is your microphone on?
It is, I believe so. Can you hear me?
No. It's like a Verizon commercial. Let's try it again.
All right. Can you hear me now?
I can hear you good. Ms. Gervin Hawkins, for what purpose?
I'd like to make a comment.
Chair recognizes Ms. Gervin Hawkins for some brief comments.
I don't think it's on.
Oh, hold on, Ms. Gervin Hawkins, I believe.
I don't think it's on.
Can you try that microphone one more time?
Testing.
I don't believe your microphone's on. We're going to work on that.
Can you
Bear
use
with me.
neighbors?
How about now, Ms. Gervin Hawkins?
Testing.
There we go.
There
Thank
you
you.
go.
Ms. Gervin
Thank
Hawkins,
you.
you're recognized for brief comments.
Thank you, Mr. Chair. A couple questions and then a comment. Is it possible that the minority party also get access to an attorney?
I'd be happy to evaluate that request. I have not received such a request.
Okay. Will any of the senators who said that the maps weren't race-baited, will they come and testify?
The chair is not advised. That would be a rather different kind of requests. I don't believe that members of each house testified at committee hearings, but the chair is happy to look at that. Chair's not advised. I know a lot of rules. Never heard that one.
Let's be the first.
Yeah, we're swimming through new waters, you know, let's add what we need. The other question is this, a couple more questions. Will you define for this group, as the chair, what you determine is a minority district versus a coalition district?
That's a legal question. Chair's not going to engage in answering or attempting to answer legal questions, not the least of reasons I'm not an expert on redistricting law.
Thank you, Mr. Chair. Will a recommendation from this committee be forthcoming to the governor?
I'm not sure I understand your question. Are you referring to a bill or a resolution?
I'm talking about the
action?
maps. Will any recommendation be coming from this committee to the governor's office?
It's the chair's intention to complete these initial hearings that have been noticed before we take up, if we take up such a question.
Okay. And my comment is this, Mr. Chair. You know, when I look at the districts that's listed on the Department of Justice letter, and I'm looking at our Congressperson Garcia, Congressman L. Green, Congressman Mark Vesey, and the open seat, the historical seat of Congresswoman Sheila Jackson Lee and Sylvester Turner. And so when I see these names mentioned, and I think of our historic and iconic members of our congressional group, I'm insulted, I'm concerned, and I'm wondering, why must we do this? And what I'm hoping, and this is to the entire committee, let's not allow the White House to put its arms into Texas and divide our community. It's wrong, it should not happen, and we want to make sure that our legislators know this is wrong, and we will not stand by and just let it occur. Thank you, Mr. Chair.
Thank you, Ms. Gervin Hawkins. Hearing no further matters before the committee.
Oh, sorry, I just
Speaker Moody, for what purpose?
Questions of the chair.
Chair yields for questions.
Thank you, sir. I was reading the proclamation that you cited, and there's a number of items that are listed in the proclamation. The one you've referred to states legislation that provides a revised congressional redistricting plan in light of the constitutional concerns raised by the United States Department of Justice, or U.S. Department of Justice, how it reads. It's within the power and the purview of the governor to convene the legislature in a special session and set the agenda for that session. Is that your understanding?
Subject to the rules of the House and the Constitution, yes.
Is there any obligation upon I'll stick with the Texas House because I don't think the Texas Senate has rules. Is it incumbent upon the Texas House to take up and pass legislation in furtherance of the governor's call? Is there any mandate that we must do so?
All legislative power is vested in the legislature. It's up to the legislature at its discretion. It's the chair's intention to take up this process, if at all, in the 2 phases mentioned.
Yeah, and I appreciate you lining that up because I think it allows for us to understand the process that we're going to undertake. But we don't have legislation before us today. There is no bill. And I know that your intent is to take public testimony at this hearing today, one in Houston and one in Arlington in the next several days. How is that public testimony going to inform proposed legislation?
All information that flows through the committee is available to committee members to guide them in making any decision, whether or not to file a bill, what the bill may look like, what amendments they may want to do to any type of bill. And so the first stage is to hear from the public to determine what they believe about whether they'd like to see revisions, and if so, what kind. And then that feedback can certainly be taken into account.
And is it the chair's intent to hear that testimony and then, as the chair, engage in drafting the legislation to bring forward?
I'm not sure what I'm going to do. I would say that we're going to hear from the public, and then once we get through that hearing in Dallas on Monday, then we'll evaluate what next steps we take.
So if that process was housed with the chair, how would the public testimony inform your drafting of that legislation?
That would be a hypothetical. I wouldn't be able to answer that at this time. I think the general expectation, and of which I've attempted to operate it the whole time I've been in the legislature, is that everyone that comes to a public hearing and gives testimony, that testimony is taken into account.
Mr. Chairman, I appreciate the time to ask questions. I know we have a number of members of the public here to testify, and to those members that are waiting to testify, the members of the public waiting to testify. This is an opportunity, as the chair stated, to let your opinion be known, and that this process should be and must be informed by your opinions about what we should or shouldn't be doing. There is no obligation for us to do this at all. At all. And I look forward to hearing from the public about whatever opinion they have on these maps. And my hope is that whoever engages in drawing these maps, because in the past it's been the chair, but whoever engages in drawing these maps and proposing this legislation also listens intently to the testimony that we're going to gather over the next several weeks. So thank you very much, Mr. Chair.
Thank you, Mr. Speaker.
I just have,
Mr. Wu, for what purpose?
I apologize, I have just a few follow-up questions.
Chair yields for questions.
I apologize, I didn't hear your answer exactly. In terms of the law firm Butler Snow, you said that is the committee's representation, or you don't know?
I'm not fully advised on the full extent of their representation. Certainly, they can and have.
Would you let us know who the attorneys are so we can talk to them directly and say, hey, do you represent us or not?
The chair would be happy to circle back with the member.
Thank you. On a quick procedural question, I know you said earlier that witnesses are being asked to testify neutral, changing no matter what they put into their affirmation.
Rules require that just because there's not a bill before the committee.
Okay. But witnesses, even though that they're listed as neutral,
they do not have to be neutral.
Okay. Thank you.
Yes, that is it's a good question, Representative Wu. Under the rules, that's just required for purposes when you don't have a bill. It's always neutral testimony to reflect that into the minutes. But members of the public are, of course, free to give any testimony that they like. Any further questions for the chair? Chair is none. Chair will move into invited public testimony. The first one we're going to do is virtual testimony. The first three that I would like to have, or first four, I'd like to have on deck, so please be ready in the virtual panel. We're going to invite you in one at a time. Ellen Katz, Ali Flores, Eric Jacobson, Robin Peoples. Our first panel for in-person testimony, which if you would, please make your way up to these chairs. I'm going to take three. And I apologize for pronunciations of any name. Nothing is intended. I'm from Southeast Texas. I like to say Southeast Texas. Maybe they don't claim us in Southeast Texas, but I like Southeast Texas, Brazoria County. Greg Cesar, Joaquin Castro, and Sylvia Garcia, if you'll make your way up to the front. So let's go to our first virtual witness. Chair calls Ellen Katz to provide invited virtual public testimony. Ms. Katz, if you'll unmute you, we're going to send you a little blue dot to unmute yourself. And if you could, make sure that we can see your video. Thank you very much.
Can you hear me?
We can hear you. Can you hear us?
Yes, wonderful. Thank
Okay.
you.
I'll show you registered. Bear with me one moment.
Sure.
Let me get your registration here. We'll be a little slow for the first few, but that's okay. We're eventually gonna get there. I'll show. Since I'm taking you out of order, Ms. Katz, I need to. There we go. Okay. I'll show you registered to testify as Ellen Katz on behalf of yourself on revisions to the congressional redistricting plan. Is that correct?
Yes, it is.
Please give us your testimony.
Sure. Thank you so much. As you mentioned, my name is Ellen Katz. I'm a law professor and associate dean at the University of Michigan Law School. And I'm speaking here in my personal capacity, not on behalf of the law school. I want to thank the committee for the opportunity to be here today, and particularly to Vice Chair Rosenthal for the invitation. In my brief comments today, I'm going to focus on the July 7th letter from the Justice Department to the governor and the AG of this state, providing what the letter calls formal notice of serious concerns about the legality of congressional districts 9, 18, 29, and 33. I'm going to make 3 points today. First, the assertion that these districts violate the Voting Rights Act is plainly incorrect. Second, the letter's assertion that these districts violate the Constitution is also plainly incorrect. And third, I want to point out that what the letter is instructing Texas to do, were Texas to do it, would in fact be illegal. More precisely, dismantling these districts, as the letter instructs, would require Texas to engage in improper considerations of race in violation of both the Voting Rights Act and the 14th Amendment. So just a quick note on terminology. The Justice Department's letter describes the targeted districts as coalition districts. It doesn't define that term, but that's a term that generally refers to electoral districts in which the combined population of two minority groups that vote as a bloc comprises a majority of the district's population. So just turning to my first point, the DOJ letter claims that coalition districts, quote, run afoul of the VRA. They don't. Last year, the Court of Appeals for the Fifth Circuit issued a decision called Petaway versus Galveston County, which held that what's known as the results or effects-based test set forth in Section 2 of the Voting Rights Act does not require jurisdictions to draw coalition districts. That is, it doesn't mandate the aggregation of two separately protected minority groups in a single district. Nothing in this decision, however, suggests, much less holds, that the VRA prohibits the very existence of coalition districts. The mere fact that a district exists in which two minority groups
Please
comprise
finish
majority.
your testimony, Ms. Katz. Thank you.
Okay.
I'll
I have a
give you
bit
closing
more to
sentence.
say. Oh, okay. I will just say on the voting rights point that it doesn't establish, and it's never established, a violation of the VRA. There are hundreds of these districts nationwide in which jurisdictions relying on traditional principles create these districts. The VRA doesn't prohibit them.
Thank you, Ms. Katz. I have a second registration from you. Do we have your permission to, you want to delete that? Do we have your permission to delete your second registration? Is that okay?
Of course, yeah, I might have not.
No, you're fine. You're just fine. We'll take care of that for you. Members, questions for the witness?
I have a question.
Chair recognizes Vice Chair Rosenthal.
Chairman, is this working? Can you hear me, Dr. Katz? Okay. And thank you, Mr. Chairman, for graciously putting these witnesses first. Professor Katz, can you please help us understand that why it's wrong that the assertion that the Department of Justice made that coalition districts violate the Voting Rights Act? I'd like you to complete that thought, please.
Sure. As I was saying, the Petaway decision says that Section 2's effects test doesn't require these districts, but there's nothing in that decision that suggests that they would that their very existence violates the Voting Rights Act. And as I was saying, is just in closing, somewhat rushed, that there are hundreds of these districts, maybe more nationwide, in which jurisdictions relying on traditional districting principles created electoral districts in which the combined population exceeded 50%, and there's no sense that the VRA prohibits them. If I may, the DOJ letter also says that these coalition districts are unconstitutional, that they run afoul of the 14th Amendment, which is separate from the voting rights claim. And more specifically, the DOJ letter says that these districts constitute unconstitutional racial gerrymanders under the logic and reasoning of Petaway. And this statement is simply incorrect. As noted, the Petaway results test held that the results test of Section 2 doesn't require jurisdictions to create them, but nothing in its logic and reasoning makes these the existence of these districts racial gerrymanders. Racial gerrymanders occur when, among other things, a jurisdiction allows race to predominate over traditional districting principles. And there's no indication here that racial considerations predominated over traditional districting principles, withdrawing of the 4 districts that the DOJ letter targets. And in fact, Attorney General Paxton noted in his July 11th letter to the Justice Department that the chairperson of the Texas Senate Redistricting Committee testified under oath that these districts were in fact drawn in a process that was blind to race, this is a quote, and sought to maximize Republican political advantage balanced against traditional redistricting criteria. Districts drawn this way cannot, by definition, be unconstitutional racial gerrymanders. If it's okay, I'd like to just offer 2 more thoughts on the constitutional claim, if I may.
Yes.
The DOJ letter also spends some time talking about impermissible race-based considerations. And it's perhaps the Justice Department means here that there's a constitutional defect in these districts apart from whether or not they might be characterized as racial gerrymanders. And it appears to be making, or the letter appears to be making, 2 points here. One is its assertion that districts 9, 18, and 29, quote, sort voters along strict racial lines. Again, Attorney General Paxton's letter indicated that race was not considered when these districts were drawn. So as a result, what the DOJ letter is calling racial sorting is instead simply the racial composition of these districts, created in what the state said was a race-neutral process. Districts created this way don't reflect any racial considerations, much less impermissible ones. The second thing that the letter seems to be saying is that District 33 is, quote, another race-based coalition district, apparently because the letter claims the borders districts resemble those imposed from a federal court order a bunch of years ago. And just 2 quick points here. District 33 borders, in fact, are substantially different from prior iterations of the district. And second, it's simply false that race-based considerations in prior iterations of the district render unconstitutional new and different district boundaries drawn for race-neutral reasons. And in fact, back in 2022, the Court of Appeals for the Fifth Circuit held in a related context that overtly unconstitutional racial discrimination animating a state constitutional provision did not taint or otherwise affect the legality of an amended version of that provision. And if that's correct, the same has to be true for considerations that were wholly lawful when made. So in sum, the DOJ is simply wrong when it states that these 4 districts target, the 4 districts it targets violate the Voting Rights Act or the Constitution. They plainly do not, and quite frankly, it's not a close question at all. I do want to make one final point, and I do promise to be brief, and it is as follows. What would violate both the VRA and the 14th Amendment would be for Texas to do now what this letter urges Texas to do. The DOJ letter is insisting that Texas now inject race-based considerations into what Attorney General Paxton said had been a race-neutral process. The DOJ letter itself repeatedly employs race-based considerations by relying on the racial compositions of these districts as the sole basis to argue that they are unlawful. The letter then calls on the state of Texas to engage in the same race-based considerations and use them as cause to dismantle the, I promise I'm closing, but I'll just add this. The Supreme Court told us already that this approach is misguided. Back in 2009, in a decision called Bartlett versus Strickland, the court held that Section 2 of the Voting Rights Act doesn't require jurisdictions to draw so-called crossover districts, which differ from coalition districts for reasons that are not relevant here. What's critical here is that it's for present purposes is when the court in Bartlett said that it was holding only that Section 2 doesn't require the creation of crossover districts in the first instance. It went on to emphasize, and again I'm quoting, I think this is crucial, if there were a showing that a state intentionally drew district lines in order to destroy otherwise effective crossover districts, that would raise serious questions under both the 14th and 15th Amendment. The July 7th DOJ letter instructs Texas to do just that is to do what Bartlett said would raise serious constitutional questions. The letter targets what it understands to be operational coalition districts, and it calls on Texas to alter their racial composition so as to render them ineffective as coalition districts. Bartlett indicated that destroying an otherwise effective district in this manner is constitutionally suspect. And so I just want to urge that Texas decline what I think is an ill-advised invitation to engage in conduct that at its core amounts to intentional racial discrimination. It should instead leave these districts in place unchanged. That's all I have, but I just want to thank you again for your time and the opportunity to be here today.
Thanks for bringing your expertise here today. I truly appreciate it.
Ms. Wu, for what purpose?
Questions for the witness.
Gentlemen, Mr. Wu, you're recognized for questions.
Thank you. I'm sorry, you caught my attention. Could you? But I was not sure of the exact answer because I was thinking about what you said. But you said the doing the mapping now would be illegal. That's a very strong statement. Could you a statement that strong? Can you elaborate on that and let's be very precise about our language?
Sure. And I intended to be quite precise about that in making that assertion. What the letter is doing is asking Texas to inject, and as I said, in considerations, race-based considerations, into a districting process that your Attorney General has said was race neutral. The letter itself is engaging in repeated race-based considerations by relying on the racial composition of each of these districts as the sole basis to argue that they're unlawful. And then it's asking Texas to now go back to the process that it says was race neutral and think about race and use race to dismantle districts that the Justice Department itself is recognizing to be effective coalition districts. Take them apart. And you can look at the decision in Bartlett. The court has made this point where